Hi, welcome back to my channel. Please like, comment, and subscribe. Maritime injury. Jones Act claims involve injuries to offshore employees. Our maritime injury lawyers in Texas and Louisiana know what needs to be done immediately. The Jones Act is the body of law that regulates compensation to workers who have been injured on or near the water, which our maritime accident lawyers use to protect injured maritime workers. The vast majority of workers who are injured on or near the water are eligible to file a Jones Act claim if the injured worker is employed as a member of the crew of a vessel or offshore oil platform. Jones Act settlements are typically quite large. The decision to hire an effective maritime injury lawyers or just personal injury attorney to handle a Jones Act claim can mean the difference between thousands or millions of dollars. When choosing a maritime accident lawyer to represent you in a Jones Act claim, it is vital that you pick a personal injury attorney who also understands the value of maritime cases and knows how to handle such a case in order to get you your just payment. History of the Jones Act. The Jones Act was passed to make sure that injured seamen received adequate medical care and compensation following a disabling injury. The law basically extended benefits to injured offshore workers that had previously been written into law for all other railroad workers. Before the Jones Act was written in 1920, laws did not exist to make sure that injured offshore workers would be taken care of prior to 1920. Of injured maritime workers could only file a general maritime law claim. Maritime lawyer, often referred to as admiralty lawyers, is a mixture of common law passed down by ancient seafaring nations. Over time, it was integrated into the American legal system thanks to the effort of great admiralty lawyers and maritime injury attorneys. Jones Act, Maintenance and Cure. There are two types of compensation under the Jones Act that maritime injury lawyers will focus on. One, maintenance, and the second is cure. Maintenance is the legal term for room and board, or more simply said, it is the money for food and shelter while you are injured at sea. Cure is the legal term for medical care. Jones Act Maintenance. First, maintenance is paid to injured seamen to help provide room and board to offshore workers who are not able to stay on board a vessel during recovery. Maintenance is calculated per diem or by the day, at a rate equal to the company's otherwise normal room and board expended for the worker before he or she became injured. Sadly, the courts have consistently upheld maintenance amounts ranging from a mere $15 to $30 per day. These benefits will be paid until the injured employee has been determined to have reached maximum medical care. If you do not hire the right maritime injury lawyer to handle your insurance claim, this may be your only legal remedy. Jones Act Cure. Next, an injured offshore worker who falls under the protection of the Jones Act is entitled to cure. In other words, an injured seaman is entitled to all reasonable and necessary medical care as it relates to the offshore injury. The concept of cure may also be extended to include future medical care for the injury, and a settlement may be reached to that end. This is where your maritime lawyer can make a difference in your case against a vessel owners. Damages for pain and suffering. If the injury was the result of negligence, then the injured worker will also be entitled to compensation for pain and suffering associated with the injury. Additionally, if your maritime injury attorney proves the injury was also partially the result of the vessel's lack of seaworthiness, then the injured worker will have additional claims for damages as well. A vessel is considered unseaworthy if the vessel or its crew were not reasonably fit for their intended use and that the lack of seaworthiness caused or contributed to the injury. The courts are typically very liberal in their determination of whether the vessels are seaworthy, and normally unseaworthiness claims have not been difficult to prove. Inexperienced maritime injury lawyers know how to pursue such a maritime insurance claim. Can dockside workers' injuries be covered by the Jones Act? The Jones Act can cover dockside workers' injuries, but this is relatively rare. In most cases, they will not qualify as seamen under this law unless they work offshore regularly. However, some maritime laws and provisions give dockside workers a way to pursue compensation and benefits after a work-related injury. A maritime injury attorney can help you identify your rights and how to file a claim. Who qualifies as a seaman under the Jones Act? The Jones Act is part of the Merchant Marine Act of 1920. It creates several duties for employers, ship owners, and others, making provisions that allow qualifying seamen to pursue damages in a negligence claim. Understanding what the Jones Act does requires understanding the law's legal definition of a seaman. The only maritime workers who have rights under the Jones Act are those who meet these requirements. Workers on a vessel that navigates offshore, not permanently docked, workers whose job contribute to the mission of the boat, workers with a substantial connection to the ship, usually spending at least 30% of their work hours at sea. A Jones Act seaman will meet all these criteria. However, if you are not sure, a Jones Act lawyer can assess your case for free to determine if you qualify for the provisions afforded by this law. How this definition affects dockside workers. Dockside workers' injuries may fall under the Jones Act under some circumstances, but this is not common. The criteria for Jones Act coverage requires the workers to spend a substantial portion of their working hours on the ship offshore. Most dockside workers do not spend enough time on a seafaring vessel to qualify. If you have questions and need to talk to a Jones Act lawyer as a result of injury anywhere near Louisiana or Texas, please contact us to have a maritime lawyer answer any questions about an injury you have suffered or to report a personal injury case you have. If you have questions regarding damages for pain and suffering, contact your Jones Act lawyer. Contact us. Maritime and Jones Act claims offshore injuries are particularly damaging because of the worker's future disability. Energy and shipping companies have great reserves of wealth and should take responsible care of their injured workers. Thank you so much for watching. Don't forget to like, comment, and subscribe.